Welcome, everyone, to a special called session of the Athens-Clarke County Mayor and Commission. It is Tuesday, August 16th, 2022, and so I'd like to begin with asking Clerk Spratlin to call roll for us.
Davenport, Parker.
Here.
Lee.
Here.
Wright.
Present.
Denson.
Here.
Poole.
Here.
Edwards.
Here.
Myers.
Here.
Thornton.
Here.
Hamby.
Here.
We got a four.
All right, thank you, Madam Clerk. All right, the purpose of our meeting tonight is to consider an appeal of an Historic Preservation Commission decision regarding certificate of appropriateness for 436 Millage Circle. And procedure for this, we'll begin with the party who filed the appeal first presenting up to a 10-minute argument in support of the appeal, and then any opponents may present their 10-minute argument in opposition. So is the party who filed the appeal here this evening?
Yes.
All right. Good evening. So
Good
just
evening.
Introduce yourself to the commission,
Sure.
and you may begin.
All right, David Ellison here on behalf of the Calhouns. We're here for an HBC appeal from 436 Millage Circle. We're here today because my clients mistakenly painted the exterior of their house. They had explored doing some renovations to their property in this historic district. They wanted to remove the stonework. They were told they could not. And when they were doing their renovations, they didn't realize that they had to get approval for paint alterations because it wasn't on the application. So I say that just to convey to y'all that they are well-intentioned. They did not mean to flout any requirements from the county. They're concerned that if this decision stands, that they will be forced to remove this paint and damage the stonework, which the historic preservation ordinances were intended to protect. So those are the facts of this case, but really this is going to turn on a legal issue about preemption and the Georgia's Constitution Uniformity Clause. Under state law, under the Georgia Constitution, state laws take priority over local ordinances. This is an example of such a state law because the General Assembly expressly called for uniform procedures for every county and municipality that adopts an historic preservation ordinance. And so I've cited a case in here. Precedent says this is an example of express preemption, that because the General Assembly said this is a uniform procedure, that preempts any conflicting local ordinance. And so whereas a change in exterior paint alterations would be a violation under the county ordinance, that is not a violation of state law. And so we are asking for the board to find that my clients have no obligation to seek HBC approval because they are merely seeking an exterior paint alteration. What's notable is that there's not a lot of case law interpreting HBC appeals in general, but one of the few examples of legal authority is this opinion from the Attorney General's office from I think 2014. And it basically, Attorney General says, any municipality that tries to regulate exterior paint alterations is going to be preempted by state law. And so what we're asking y'all to decide is to modify the determination for the HBC to find that no certificate of appropriateness is needed in this situation because there's an exception. There's an exception under state law that you don't need approval when you're making an exterior paint alteration. And that's precisely what happened in this case. Thank you.
All right. Thank you, Mr. Ellison. Is the other party here to stand in opposition? All right. Given that that's the case, we'll go ahead and begin deliberation by the body. And certainly members, you know that we have with us Austin from County Attorney's Office for any internal expert information that you would wish to access. Commissioner Hamby?
Sure. I appreciate the opportunity to speak, Mayor. And I've been through this. I pass by this house every day in this neighborhood every day in the historic district that is just recently new, fairly new historic district. And I've noticed what's been done and noticed the work, and the house looks good. The work that they've done on the house looks good, and I'll have to say I would probably make the same mistake, considering you know what I know about historic preservation and going through the HPC and such as that. So I'm just gonna go ahead and, if it's all right with y'all, just make a motion to approve what the HPC has done, but modify the decision and allow the paint to stand and for the COA to be issued.
I second it.
I've got a motion from Commissioner Hamby, second from Commissioner Thornton. Commissioner Thornton, any follow-up as seconder?
No, I guess if we're going to just move to a vote, I don't want to hold up the process, because I was going to ask the attorney, two things that was stated. One thing that was stated was that the painting of this facility or any facility was not part of the applications or recommendation. It was not spelled out. Did I hear that correctly?
That's correct. The HPC, the application for a COA did not include any reference to painting or sealing the rock on the historic structure.
And my next question then, if the vote goes the other way, what are the legal ramifications, since it looks like we are superseding state law? Is there another step for the applicants to take if they're not happy with this decision?
Absolutely. And so for this, like for y'all's purposes today, the standard of review is abuse of discretion, and we're essentially just looking at the record that the HPC considered and analyzing whether there is any evidence in the record to support that decision. Regardless of how the body rules today, the applicants will still have the opportunity to pursue other avenues in the courts and appeal this up the chain, so to speak. I believe the next step would be an appeal to Superior Court, where the appellant's legal argument would be able to be considered.
Okay, thank you.
Commissioner Link?
Yeah, the guidelines are clear that brick and stone should not be painted, that these materials are integral to the design features of the homes and the time periods in which these historic structures were built. And there's a good reason for that. Often paint can damage those materials. It can degrade brick. There are chemical reactions with some paints that can actually cause brick or mortar to degrade and eventually compromise the structure of the home. That said, to remove that paint would degrade it even further. That's part of the point for not putting paint on a structure in the first place, because the removal process is degrading. I think I've been to at least a couple HPC meetings where you have had an applicant request painting brick, and in some cases it is found to be appropriate because of the time period, or they state the specific kind of paint. I think that maybe we need to do some educating of, because we do have a lot of newer historic districts. I think we need to possibly reach out specifically to those who own structures that are brick or stone and remind them that, that this is part of the guidelines, that they should not be painting that material. It's kind of all the rage today to whitewash or gray wash every frickin' structure out there. It's a real trend, and it's a trend that's not going to stick around, but people are really into it. And it's really going to damage a lot of these historic structures, whether they're in historic districts or not. So I hope that maybe our planning department could do some kind of outreach, maybe some kind of PR campaign to people who specifically own these structures, because at this point on this particular structure, the damage is done, and it would only cause further damage to try and remove that.
Further input or questions?
Question, Mr. Mayor.
Yes.
Mr. Jackson, I know we've heard the position that the HPC here locally can't govern a paint alteration, but the way that I read this case is it's not applicable because there's no alteration. there was no paint to begin with, so sure, if your house is already painted, then you can paint it a different color. That would be an alteration. We can't govern that at a HPC level, but here, there was no paint. So is that sort of why that applies here?
That's correct.
Okay,
As I outlined in my memo, there's a distinction between the
Yeah.
alteration of existing paint
Yeah.
and the addition of paint that wasn't there previously.
right. So, just to be clear, we're maintaining the integrity of our HPC ordinance, but I do believe that, as Commissioner Hamby said, agree with our HPC, but I guess issue a modified order, seeing that, as Commissioner Link said, to sandblast these layers of paint off of this rock masonry would most likely do more damage to the structure and further sacrifice the integrity of the structure. So in light of that, while maintaining the integrity of our HPC ordinance, granting the relief sought by the petitioners here.
Commissioner Denson.
Thank you, Mayor. And while I think I will support the motion, I do have concerns with these kind of after-the-fact situations with our historic preservation appeals. I think it's the second time this has happened since I've been in the body where we've had something come back to us, in which something was done incorrectly, actually harming the historic preservation and the whole intent of the policy. And yet, forgiveness was done. I do fear the precedent this can set with people just simply, going ahead and doing the work and dealing with the consequences later. And sometimes there aren't consequences. So, I think I will support the motion, but, we have to be able to stand behind our HPC did the correct thing here, and we need to ensure that applicants are following the procedure correctly so that we don't end up in the situation in the first place.
Commissioner Houle.
Thank you, Mayor. I'm just trying to get a little clarification on the motion. I mean, we're being asked essentially whether HPC abused its discretion. And what I'm understanding from the motion is we're saying, no, the HPC made the appropriate decision, did not abuse their discretion, but we're simultaneously going to allow the paint to stay. And I guess I'm just curious, where does that leave things moving forward from this point for the property owners in question?
And I guess, Attorney Jackson, I might ask, is the motion in the appropriate form that we would need?
Yes, because there is an option to approve the decision of the HPC, but also modify the decision, if I'm understanding your question correctly.
All right, there is a motion from Commissioner Hamby and a second from Commissioner Thornton. Can you do a roll call for us, please, Clerk Spratman?
Hamby,
Yes.
Parker,
Yes.
Link,
Yes.
Wright,
Yes.
Benson,
Yes.
Poole,
Yes.
Edwards,
Yes.
Myers,
Yes.
Thornton.
Yes.
9 yes, 0 no.
All right, thank you, Madam Clerk, I appreciate that. All right, we have a separate special called session for executive session, but I would entertain a motion to adjourn this session.
So moved.
I've got a motion from Commissioner Thornton, I think second from Commissioner Wright, and all in favor?
Aye.
All right, any opposed? All right, see you back here at 5:30. Thanks, everybody.